Good evening and welcome to this session of the live virtual classes conducted by the Board of Studies of the ICAI. In the last session, we began with preliminary and then we went on to incorporation of companies. Now, there are certain, the issue is, this is not a full-fledged class. So I'm only going to go through certain important topics, possibly from subject point of view, from exam point of view, whatever. It is expected that you would have already seen the video for the topic. Okay. In spite of that, I find even if I do a bare minimum coverage, I have to do some coverage. So the plan of the evening is like, till say 8 o'clock, we'll do this discussion. I will give some ideas. Thereafter, possibly today I will cover this and prospectus. If I can cover share capital also, I'll do that. Try my best. Right. So that being the case, we will see. If you have any doubts, you can ask. But then my suggestion, of course, from what I'm now going to tell you, you will want to raise queries. I'm happy. From this topic, elsewhere also you can ask queries. So my suggestion. Also, you can use the query pad to ask queries, which I could take as and when you raise the query. Ms. Satya Gupta starts off the day with a query which says, what is the difference between winding up of a company and removing its name from the register of companies? Yeah, removing its name, it's known as striking off. That is not in your syllabus. So one more thing, winding up is not in your syllabus. Satya ji, so would you want to have information about something which is not in your syllabus? Why don't you concentrate on something which is in your syllabus? Basic difference is winding up is a process by which the asset. Listen to me, Satyaji, so that I will clarify this doubt once. Because you have raised it, I am giving the knowledge to you. Not required from this current exam point of view. Okay, winding up is the process by which the assets are sold, the liabilities are settled, the creditors are paid. If anything is left over, preference and equity shareholders are paid. Finally, an application is made to the tribunal by the liquidator and the company is dissolved. So it's a whole process. Winding up is a whole process of selling, paying, and then applying to the tribunal, giving a report. Official liquidator gives the report, then everything over. Then the liquidator ensures that the dissolution is done. The process of actually killing the company is called dissolution. The process of selling the assets and making it a shell is called liquidation or winding up. Striking off is where the company is not functioning at all. For 3 years, nothing has happened. Financially, there is no transaction. The company is not filing its annual return, financial statement, nothing. Knock, knock, who's there? Nobody. So the registrar sends a letter asking, are you alive? No reply. Another letter, registered post, are you alive? No reply. Then unilaterally, the registrar makes the assumption that these companies are all dead and they publish in the official gazette the names of the company. There again, they give an opportunity. If you come now also, we will take you back. But then these companies don't respond, then the name of the company will be struck off the register. And so if you go to the register of companies, the MCA site, and you go through companies ka list, sometimes you will find inactive or defunct like that. So they are companies that have been struck off. Okay, so they are in the process of being struck off. So that is something. So basically, it's a unilateral process of law as against winding up, which is a regular process controlled by law. Okay. So we left off at a point where we went through all this and we came to articles, then we saw entrenchment, right? And then we went to entrenchment, how entrenchment is done, right? We also saw that in order of superiority, the Act is supreme, followed by the Memorandum, and finally the articles of association. So, section 6 gives this hierarchy: memorandum, articles, act, memorandum, articles. But then, where in the act, they say save as otherwise provided, save as otherwise provided. That means normally the act will override the memorandum. But in the law, wherever the law says, wherever the act says, articles can be different, articles can speak differently, or articles can state something different, or a section may be made not applicable by the articles, then those sections will, the articles can provide whatever they want. An example is section 47, which we'll be seeing when we come to share capital and debentures. There it talks about voting power of members, changing that and all that. This section is actually applicable to private company, but if the articles of association say it is not applicable, then the articles can say it is not applicable. So if the articles are silent, then act will prevail. So 47 will be applicable. But if the articles consciously say it is not applicable, then articles will be superior and 47 will not be applicable. Whatever the articles is saying will be applicable, or 47 will not be applicable. So in some cases where the act itself provides, then the articles can be different from the law. You have to be careful. Wherever save as otherwise provided in this act. So this section itself begins as save as otherwise expressly provided in this act. Expressly means by words clearly written or clearly mentioned, by words expressly. Implied means by conduct, course of conduct. Express means by words spoken or written. In this case, by written words, because Parliament will not speak. They will only write. They will give a printed document called act, wherein it will be expressly provided. Expressly means clearly, unambiguously, it should be said. You can't infer it. You can't infer by something. No. It has to be clear and unambiguous. Now, the memorandum and articles are contracts. Basically, the memorandum is a contract. Articles are also contract. Memorandum is the charter by which the company comes into existence. Articles are rules and regulations. Both are together a single. They make the totality of the contract. Okay, between the company and its members, and between the members inter se. Inter se means amongst, between them, between the members. So basically, inter se means between. Is a Latin term. Inter se means between. So between members or amongst themselves. Between members, amongst themselves, or between themselves. Okay. Correct. Now, some students have a problem in accepting this rather than understanding it. Simple, sir. A and B are having a contract. By that, A and B, look at it from A and B point of view, it will be very easy. A is one human being, B is another human being. A and B are having contract, by which A agrees to appoint C. A and B, maybe A and B are there. Now B may do something for A may do something for B, consideration is there, whatever it is, as part of that, C should be appointed. No, C is a party to the contract. No. Okay. Stranger to the contract cannot sue. You may be stranger to the consideration, but you cannot be stranger to the contract. Go back to your contract act, you will understand this. You may be stranger to the consideration, but you cannot be stranger to the contract. Okay. Therefore, here, he is a stranger to the contract. Because the contract is between who? Once you saw A and B, you understood it very clearly. If C is not appointed or C is removed, B can sue A, but not C, because C is not a party to the contract. He has no locus standi. You're able to understand. Therefore, B is the party to the contract. Here, in this example, A is the company, artificial person. B is not just one person. B is a whole group of people called members. Now, there is a contract between the company and the members, which is represented by the memorandum and articles. In that articles, it was mentioned that Eli should be a solicitor for life. In the articles, which is basically a contract between the company, in our case A, and the members. All of them are B1, B2, B3, B4, like that. All of them. So collectively, they enter into a contract between each other, B1 with B3, B4, B5, and also all of them with the company. There is a contract. That contract is between these people, the privity of contract. The word privity of contract, if you have studied in Contract Act, I'll be very happy. If not, now I will tell. That is exclusivity. The contract is between the company and its members. Now, Eli is named as a solicitor for life to the company in that articles, and that he should not be removed except for misconduct. Now, Eli is removed. Okay, now Eli is definitely affected, no doubt about it. But he is not a stranger, he is a stranger to the contract. He has no business to come, even though he may be a member. Please understand, Eli as a member has certain rights. What are these rights? To receive annual report, notice of annual general meeting. If dividend is declared, to receive the dividend, to vote at the meeting, appoint proxy. No, these are all rights available to Mr. Eli as a member. If these rights are violated, Eli can sue. But as an advocate, Eli has no right. Are you able to understand? The fact that he is a member also will not be relevant. The case of Eli versus Positive Life Government Security Life Insurance, Positive Life Assurance Company was dismissed because Eli filed a case asking that he is entitled through the articles. Now, the court very clearly said Eli, as a solicitor, was not party to the articles. He must prove a contract independent of the articles. In the absence of such a contract, he couldn't sue as there was no infringement of his right as a member. I find many students find it very difficult to understand this. The reason being, they think Eli is affected. See, because somebody is affected, law cannot help him. Law can help him only if he is party to their contract. So Eli was not party to the articles of association. As a member, he can sue, but not for this appointing him as removing him as a solicitor for any other infringement. When the majority later on in final, when you come to oppression and mismanagement, you will again see this. Once the majority makes a decision, one individual shareholder cannot file a suit on any matter. Whatever decision taken by the majority is final. So the company as a group, they have very clearly said, chuck Eli out. Now, even though Eli is a member, he cannot file a suit. Okay. So, Satya Gupta is asking a doubt I don't understand. Section 8 company, since registration of a company is mandatory, how can a company exist if its name is struck off? Company does not exist. If the name of the company is struck off, what do you have to do? See, it's a very complicated topic, Ms. Gupta. You are asking a doubt which is outside of your syllabus. Section 8 company, all you need to do is how to form it, how to register it and all. If it's striking off is not in your syllabus. Okay, one. So in the context of Section 8, I don't know where is the problem. You can always see, you incorporate a company, then make an application to the regional director for dispensing with the words private or private limited or limited as the case may be from the name. That's it. Thereafter, if that company does not file the return, etc., it will be struck off. Striking off is a different process. Okay. So your doubt itself is not clear to me. But please understand, you are entitled to ask doubt. I am only telling you this is not relevant from your exam point of view. From knowledge perspective, I have explained to you. I have no problem in explaining. But it's not relevant. There are more relevant questions connected with your topic. That's all I'm trying to say. Okay, which you could try to go through. So, see, when a name of a company is struck off, it won't be immediately dissolved. They'll keep it in abeyance for 20 years. You have time for 20 years to revive the company, because suppose you're a creditor who has supplied goods or lent money for 20 years, you have time to revive the company, then go through a process of winding up. Thereafter, you can go through the process of winding. See, this whole striking off of name is a topic by itself. Okay, not in your syllabus. Later on, once you complete your intermediate, you come to final, it's a topic by itself when you will study it. In this stage, don't too much get your head wrapped around this topic. So striking off is different from winding up. I hope you are clear about that. Once a company is dissolved, that's it. Within 2 years, you can go for resurrection of the name, but restoration of the name, it is called. If you don't want to do it, that's it. Whereas here, you can go for revival of the company within up to 20 years, you can go. Striking off. After striking off, you have 20 years to go. You can go to tribunal, and tribunal can reinstate the company. All that. So now we come to the 3 doctrines. Let's quickly go through the 3 doctrines. Basically, doctrine of ultra vires is nothing but the memorandum and articles of association. The memorandum and articles of association are, once again, Eli matter, Ruhani Jain has a doubt. Confirm if my understanding is correct or not. Eli contracted the company the capacity of, so he being member of the company. Eli had no contract. That is the point, Ruhani ji. Hello, Eli had no contract as an advocate. As a solicitor, he had no contract. That is the point. As a member, yes, the articles, he is as much having a contract as every other member. Okay. So the point you should understand is, he did not have a contract as a solicitor. So your understanding is wrong. Eli had no contract with the company in the capacity of solicitor, only as a member. Therefore, since there is no contract between him and the company as a solicitor, he cannot prove in the contract, in the articles. That is the crux. You understood exactly opposite. The crux is he had no contract as a solicitor. As a member, your rights are very limited. Eli as a member, Eli as a solicitor. Eli as a member, what are the rights? Notice, I told you all this. Maximum he can attend the meeting. When they are proposing to remove him, he can vote against it. 1 vote. Or if he's having 100 shares, on a poll, 100 votes. But if the majority is for removing him as a solicitor, that's it, end of story, no more. Okay, Eli as a solicitor, I know. What is he intelligently? Eli being a solicitor, he should have had some intelligence. What he should have done, once the company was incorporated, he should have told the board of directors to enter into a fresh contract with him for appointing him as a solicitor. Thereafter, there would be a direct contract between the company and Eli, the solicitor, by which the company agrees to make him lifetime solicitor. And if he is intelligent, what he will do, because even if he is appointed lifetime, the members can remove him. In which case, what he can do, he can put a penal clause and say, in case they remove me, they have to pay me damage of 20,000 pounds. See, are you able to understand? This is the way Eli should have thought, being an advocate and solicitor. But stupidly, what he didn't do anything. Then he relied on the articles and misused it. No. The law said, no. You are not a party as a solicitor. You are only party as a member. So don't come on the articles. If you have another contract, please show. If not, get out. So this is the decision. See, many of you your understanding of law is more important than what you think is right and wrong. Don't confuse what is, sir, Eli is a poor boy, poor Eli, sir, like that. Eli may be poor, bad, your sympathy may be with Eli. But law is the law. Okay, when you're studying law, be careful. The sympathy and all cannot work. Your sympathy is of no value to Eli. If you have any legal point, please give him. Okay, in the exam, you cannot write Eli is unfair on Eli and all. You will get 0. Okay, whereas this is the answer. Here I put now the word ratio, I have put now, what does it mean? Reasoning. Ratio decidendi means reasoning, logic, how the decision was taken, the word ratio. So basically, the scope of what the company can do, the scope of what the company can do is defined by the objects clause of the memorandum. Okay. Now, so if the company enters into a contract for anything which is not mentioned in the memorandum, it is called ultra vires or beyond the powers. Such an act cannot be ratified even with the consent of all the members. Suppose the company object class says manufacturing of sugar. Example, manufacturing of sugar, whatever, blah, 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 sugar. So any contract which is to do with sugar industry or related industry, like, I told you the other day, molasses, power generation, no problem. Within memorandum, I will very clearly provide for all that. My main object should be there. Suppose such a company enters into a contract for construction of a cement factory project. Now, the contracting company, for building that cement plant, they are entered into the contract. Later on, some payments are made, contract is done, some default is there. Now that construction company sues the sugar company. Now, it sounds, I know again, some of you will get very angry. It sounds very unfair, but I'm teaching the law. I'm not here to teach fair and unfair. I'm here to teach you the law. So don't, you get tense, what can I do? You tell me. So the point, my dear friends, is sugar factory can enter into a contract. The directors can enter into a contract for sugar. For cement, if they enter into any contract, the act is void ab initio. An act which is beyond the scope of the memorandum or articles is ultra vires and void ab initio, which means what? Any amount received under the contract has to be refunded, and any amount due will not be paid by the company. The company is not liable to pay. Why? Because the contract is void ab initio, from the beginning. Ab initio means from the beginning. You know that, I'm sure. Ab initio means from the beginning. Okay, sabse pehle, from the beginning. Okay, now, this was laid down in a famous case called Ashbury Rail Carriage Company versus Rish. Famous, delivered by a Lord. It's House of Lords decision, delivered by Lord McNaughton, wherein he said not even all the members of the company can ratify. See, let's come to the point. Suppose, according to the articles of the company, if the directors want to borrow money, they have to take the approval of the shareholders. Beyond 100 crore, if they want to borrow, they have to take the approval of the shareholders. Suppose the directors borrow beyond 100 crores without approval of shareholders, but the borrowing is for the sugar. And for what it is worth, there was a good reasoning. They have done good only. They have not, intentions are honorable, but they forgot to get the approval of the shareholders. Now, theoretically, the shareholders can meet, understand what happened, appreciate that it was all done in their interest only. Then they can ratify the whatever done. Though it is wrong, though it is incorrectly done, they can ratify it, because the act done by the directors was beyond their authority, but within the scope of the memorandum, because the borrowing was done only for the sugar business. So the borrowing was done for, maybe the CC limit was enhanced, but the enhanced amount went beyond 100 crore. They were in a hurry to go to the bank. So they forgot to pass a special resolution. Bank also forgot, no problem. All that the company has to now do is ratify, pass a resolution and say, whatever you did, we ratify. We now approve it. It is possible to have ratification because it is not beyond the scope. Okay. Are you able to understand? See, there is a boy, father tells him, you marry whomever I tell you to marry. Boy also shakes the head. Later on, he goes, gets married to a girl who is possibly not approved by the father, but a bad girl. Later on, the father may change his mind and say, I bless you. That is called ratification. Act was done without my consent, but now I am giving my consent. It is possible to ratify only if I can ratify it. But if it is something that is beyond the scope of the memorandum, then all the members cannot ratify it because it is beyond them. They themselves cannot ratify. Therefore, an act which is beyond the scope of the memorandum of association is ultra vires and void ab initio. See, the purpose of the doctrine is twofold: to protect the investors and to protect the creditors. Remember the two pillars: to protect the investors, because think about it. I am an investor. I am going through your memorandum and articles, which are public documents. I find therein that you are a sugar company. I honestly believe that my money will be used for manufacture of sugar. Now, if you are going to quietly set up a cement plant, then my money cannot be used for that. Therefore, if any contract you enter into will become void ab initio. It is to protect the existing investors. Wait. Similarly, it is to protect the existing creditors. Boss, we lent you money based on the sugar business. Now, if you're going to take up some other risky business, my loan cannot be used for that. In case that business is lost and you become insolvent, why should I be affected by it? Therefore, we are protecting the existing creditors and the existing investors. If you keep this in your mind, then you will understand. If you are worrying about the guy who lent the money, don't worry about him because he has no business to lend. Why? Because what he should have done, that lender of that money to that for the cement activity, what he should have done, he should have verified the memorandum of the company. Where he'll go and verify, he need not ask the company. The memorandum is a public document. Okay. And therefore, you are supposed to go and verify the memorandum. And once you verify the memorandum and find the cement is not there, jolly will tell him, I won't lend you the money. Or you tell him, you amend the object clause. Change the object clause. Include cement in it. Get the approval of your members for getting into cement business. Once you give me the amended memorandum, yes, Baba, I'll lend you money. So the idea is you are entitled to do only what is stated in your memorandum. Okay. So that memorandum becomes very important. See, arising from this is the doctrine of ultra vires arises out of the doctrine of constructive notice. What is constructive notice? Constructive means deemed. Notice means knowledge. Constructive means deemed. Notice means knowledge, which means deemed knowledge. Meaning what? Boss, you are now going to enter into a contract with me. You are a creditor. You are going to supply goods to me. Now, I need not give you the memorandum and articles. If you want, you ask me, I'll give you. That's different. But if you are not asked and I have not given, it is not my fault. Why? Because I filed the memorandum and articles with the MCA portal. Every document I filed with the MCA portal is a public document. And any public document, you are deemed to have notice. So the doctrine of constructive notice is a rule of presumption. The presumption is that a third party proposing to deal with the company has read all the document filed with the ROC. Therefore, he is expected to know what the company can and cannot do. He cannot later plead ignorance. If you understand this, you will see that the bank which lent money without seeing the memorandum, or the lender who lent money without seeing the memorandum, or the supplier who supplied goods without seeing the memorandum, definitely is guilty of negligence. You should have verified. Okay. Nevertheless, it is still this. Some of you might still feel that this particular doctrine is a bit of a fraud on the creditor, unwary creditor. In fact, my Guru Professor K. Santraman used to say, the doctrine of ultra vires is a fraud on the unwary creditor. But then the law is meant for a valid reason. The law is meant to protect the existing investors and the existing creditors. Their money should not be frittered away. See, I'm giving cement and example of cement and sugar. Think about it. There are many cases where I know for sure some groups where the company will be doing X business, which is profitable, boring business, but very profitable. Suddenly, some newfangled idea comes like infrastructure development, Bitcoin, etc. So one of the directors, one of the sons possibly says, our company should get into Bitcoin. Our company should get into infrastructure, whatever. Now, we are the shareholders. We don't want it. So without telling us, if you go entering into a contract, without amending the memorandum, then that contract company is not bound. Right. Now, the doctrine of constructive notice is a rule of presumption, sir. What does it presume? That you as a third party or I as a third party have gone through all the public documents. So I went through your memorandum. I went through the articles. I found that if the directors are supposed to borrow, they have to get an approval from the shareholders. Now, so, boss, I'm aware. I'm coming to you. I'm asking you, have you passed a resolution? You are saying, yes, we have passed. You are the company. You are saying, yeah, we have passed. Then I ask for a proof. You give me a proof. That's it. Tomorrow you cannot come and say such a resolution was never passed because our board meeting was never held. It is all fraud like that. What's my problem? You said, as per your articles, you have to pass a resolution, board resolution. Members resolution. You produced a document to me purporting to be a certified copy of the proceedings signed by somebody who is the chairman. I went to the MCA side. MGD 14 was filed. This fellow chairman is a member director. Directors who are attending are all at that time directors. That's it. If actually that meeting was not conducted, Baba, what can I do about it? That can never be brought to me, because if you tell me so, I cannot assume what happened inside your board meeting. That will take me indoor. It's called doctrine of indoor management. See, there are two aspects of a transaction. One is called substantive. That is what has to be done. And the other is called procedural, how it is to be done. See, incorporation of company, there is a substantive law, which says you have to go to the registrar, you have to get the name, etc. Now, how it is to be done? There are the forms and procedures. So that is called procedure. Now, I am a third party. I can have knowledge of the substantive and procedural aspects. But how can I find out whether the procedure has been actually complied with? Therefore, he can presume in his own favor that things which ought to have been done regularly have been done regularly. This is known as the doctrine of indoor management. In a way, you can say the doctrine of indoor management is an exception to the doctrine of constructive notice. See, the doctrine of constructive notice is a rule of presumption in favor of the company against the third party, where the constructive notice says third party cannot say I was not aware and all. Whereas doctrine of indoor management is a rule of presumption in favor of the third party against the company, wherein very clearly the third party can say, look here, I know what your procedure is. I have seen it. I have asked you. But today you are saying it was not done. That I cannot do anything. Because if I try to examine all that, I have to come indoor. This word was actually used. The word indoor was actually used in the case Mahoney versus East Hollywood Mining Company. Though the doctrine of indoor management is better known or well known as Tarkan's rule. So sometimes, this doctrine of indoor management, instead of calling it the doctrine of indoor management, it is also called Tarkan's rule. Why? Because this doctrine was first laid down in the case of Royal British Bank versus Tarkwan. Royal British Bank versus Tarkwan. One of the popular questions raised by students, I'm sure some of you are having this in your mind also, is Sadab, I'll come to your point. Good question. I'll come to your point. Sadab, wait. Good question. See, first let us understand this doctrine of indoor management, which we are now there. Indoor management is a rule of presumption that whatever is the procedure I have seen was correctly followed. So long as I confirm that it was done and you tell me it is done, maybe some proof I need here. That's it. That is why banks generally ask you for a certified copy of the minutes of the meeting. Also, they verify whether that if it is a special resolution, whether that MGT 14 form, which is later on you'll see it in management and administration, whenever a special resolution is passed or certain resolutions are passed, you have to file MGT 14. Whether MGT 14 has been filed. If that proof is given to the bank, that's it. Reality, whether it was done or not, how I can find out? Okay. So in Royal British Bank versus Tarkan, the company had powers to borrow money provided a proper resolution was passed. The company borrowed money and issued bonds. The resolution was not in fact passed. It was said that the company was bound. Okay. The fact that the resolution was passed did not affect the bank. It was not, see, they said it was passed, but it was not in fact passed. Okay. The bank was bound to inspect the articles, which it did. Beyond that, they were neither bound nor entitled to look. Otherwise, it would take them indoor. What happened in the boardroom? How do I know? What you filed only I can see. That's a black box for me. That's why in Mahoney versus East Hollywood, a similar view was given wherein they use the word indoor. But then there are some exceptions to the doctrine of indoor management. Persons purporting to act as directors or having actual knowledge. Boss, you are saying that you lent money to the company. You are a director. You are a director. You have lent money to the company. You as a director will be well aware what happened in that board meeting because you are having actual knowledge. At that meeting, you know very well you are lending 1 crore and you know that beyond 50 lakhs, a resolution has to be passed. Now, when you lent 1 crore, you as a director, you are party to that resolution of lending. Now, you cannot now come and say, you know what, how do I know it was actually passed or not? Brother, you well knew you were there, it was not passed. So, how can you say, how could I know? So, persons who are purporting to act as directors are having actual knowledge of the irregularity. Similarly, in Morgan versus Canson, it was very clearly easy. M is not a member. Okay. To one director who was removed, along with another man who was never a director. Together they appoint this M as a director. Then they go on to allot shares. M is well aware of the irregularity. When M is well aware that the guy who is appointing was already ceased to be a director, and the other fellow is not even a director. Knowingly, you have entered into this. Together, you three fellows have allotted shares to you. Now, later on in the liquidation, it is clearly shown that these shares are forgeries. Now you cannot say, you know what, I'm a third party. How do I know about the irregularity? Sorry, you are very much having knowledge of the actual knowledge of the irregularity. Okay. So this is available only to those who are behind the screen. I have not gone inside. Then only I can say I can claim indoor management. When I am sitting indoor, I cannot say I am protected by indoor management. Right. See, what the act done is ultra vires the company itself, then not even all the shareholders can ratify. Right. Not even all the shareholders can ratify. Now, Sadab is asking a nice question. He is asking, what happens if the directors don't ratify? See, here we said, where something is intra vires the directors, then it can be ratified. Now he is saying the directors have done something. I gave an example, which is they borrowed for the sugar, but it was incovered. So, sir, believe me one thing. Suppose the money was received by the company, right? No doubt it is ultra vires the directors, but it is not ultra vires the company. So, in a liquidation proceedings or in insolvency proceedings or in court of law, if the bank is able to show that they genuinely wanted to know everything and it was all proved and they got the memorandum, etc., and they honestly believe that the directors will get the approval, then the bank can either claim. See, your question was what happens if the shareholders do not ratify it, right? Agreed. If the shareholders do not ratify it, only 3 options are possible. 1, the money was paid to the company and utilized now. To the extent that the money was actually utilized by the company, the bank can file a suit and claim, because when you got the money, you used it. To that extent, they can prove their claim because they lent it in good faith. Later on, when you come to final, you will see that even in some cases where there is a violation, a lender who lends in good faith without knowledge is still protected. Okay, that is the only way. But if you are also aware of the irregularity and you have lent it, then you are also not protected. Maybe the bank can take action against the directors who have induced it to enter into it, but the company cannot be made liable. If the shareholders refuse to ratify it, then sorry, either you show indoor management. If it is ultra vires the company itself, then nobody can ratify it. But if it is ultra vires the company, but the company refuses to ratify it, then sorry, the third party will have to proceed only against the directors. But to the extent of the amount actually paid and used by the company, they can prove in liquidation because they'll say, look here, my money I gave, you refund my money back with whatever it is. Because honestly, agreed, I'm not enforcing the loan, but any amount actually paid by me will have to be refunded. Okay. So that is not under the Companies Act. Okay. That is not under the Companies Act. That is under the Specific Relief Act you can claim. Because you gave money, it was taken, proof is there, you did it in good faith, then you can recover that. Only that amount. You can't enforce the contract, but you can recover the amount already paid with reasonable interest as fixed by the court, for which you have to file a suit and collect it. This is the legal answer to your question, sir. Okay. The question is very practical in nature because the Companies Act doesn't contemplate such a situation. The Companies Act is only an enabling law. So for that, you have to go to the civil law, where you have to file a suit for amount actually paid. But you can't enforce the contract because if the contract is not ratified, then that contract is out. You have to try your luck in the normal law, the civil law. Okay, nightmare. So the real learning I'm getting out of this, if you're worrying about all that, there are two ways of looking at it. One, if you are the CFO of a company or the chartered accountant in charge of a company's financial affairs, see to it that whatever your board of directors is doing is done as per the articles and memorandum. Please. If not, amend the memorandum and do it properly. This you owe as a professional. Secondly, if you are a banker, if you are employed by a bank or an NBFC, before you lend it to a company, hire a company secretary, do a proper, complete inspection of the records, including memorandum. Do a thorough study and get all the documents cleared by the company and ensure that you have proof of everything. Okay. And then only you should lend the money. Otherwise, it will be a big joke and problem. Mr. Akash, what is the difference between special resolution, board resolution, ordinary resolution? Can I explain? Yes, I can. Will I explain? No, I will not. Why? Because it will be explained when I come to management and administration in detail. Because if I start that explanation now, we will go tangentially. The nature of the subject is such that special resolution will be used by me regularly, but it will be explained only when you come to management and administration. Okay? Because you cannot appreciate it unless you understand meetings. But if possible, if time permits today, I will explain. I will do my best. But it will be anyway covered when you come to management and administration, where the specific section 112 will be dealt with in detail. In the meantime, I can tell you, but not abhito nahi. Maybe if time permits at the end of the class. In the meantime, you will come across this term regularly, special resolution, etc., etc. So you should be a little patient. There's no other go. Now, I'm going to talk to you a little about alteration of some of these classes. For example, alteration of name class, alteration of object, and quickly. So, if you want to alter name class, a special resolution is to be passed. So the name implies, no, it is a special resolution. That means what? In very simple terms, Akashji, I will tell you. Who pass ordinary resolution? Who will pass or who should pass? Who will pass? I think. Sorry. Okay, who pass ordinary resolution? Who will pass? Preetiji. Who will pass? Okay, Akash, since you're asking the doubt and it's very fundamental for your, and it's necessary for your appreciation of this topic, I will explain to you quickly. Listen to me. Ordinary, special. Ordinary means simple. Special means something important. So the law wants to be clear. First of all, there are basically two types of resolutions. One, board resolution. B-O-A-R-D, board resolution. What is that? Resolution passed in the board meeting is board resolution. So company has two types of people. Now, one is the directors. The directors are the guys who manage the company day to day or control the company. They are called director. They are the management. Then you have the members who are the owners. So basically, there's a dichotomy. The management is the board of directors. The ownership is with the members. So both of them will have meetings. The board of directors will have regular meeting for running the company, borrowing money, selling asset, buying asset. All these decisions are taken at the board meeting. Resolution means decision. So any decision which is taken by a group of people is called resolution. Even you will have passed a resolution on the 1st of this January. You would have, all of you, not only you, Akash, everybody here would have written down in the diary, I will be good. I always write. So I will be a good man, very difficult. Okay, whatever. I don't know. Okay, whatever. I have a different approach. I don't write resolutions. Rather, I have plan. I have vision for the next 5 years. Then to achieve those 5-year visions, I have clear-cut action plans. Okay. So sorry, I'm not into resolutions as such. But there are many people, because the resolution is just exactly that. You tell yourself you'll do it, but you will never do it. Whereas I don't have resolutions. I have action plans. Very clearly, I have action plans, deadlines, and I act on them and I achieve them. Sorry, this is how I've been right from the age of 15 till 58 now. I've never made resolutions. I will do it. A sankalp karna. No. No sankalps. It's karna. Straight away do. No question of sankalp. Okay. But sometimes, we write down resolution. I'll be a good person. I will go on diet. I will study carefully and somehow clear the CA intermediate. Whatever. These resolutions are there now. They are decisions taken by you as an individual, documented now. Similarly, the company, when it takes a decision, that will be done only by majority agreeing to that. That is called resolution. Similarly, when the board takes a decision, that will be documented because it will be done in the board meeting. In all cases, majority will always have the way. Majority means 5 people are there, 3 is majority. Means the number of votes cast against or number of votes cast in favor should be more than number of votes cast against. The number of votes cast in favor should be more than number of votes cast against. So board resolution, normally it is 1 person, 1 vote. So if there are 5 board members, each will have 1 vote, 1 person, 1 vote. So 5 members, 5 votes. Out of that, 3 in favor, 2 against, resolution passed. Board meeting may simple, 1 person, 1 vote. Whereas when you come to company meeting, then the whole thing will change. So shareholders are, of course, individually they are there, but each shareholder may hold a different proportion. So 1 share, 1 vote. Please note, on a poll, it is 1 share, 1 vote. For our current knowledge, that is not very relevant. What you need to understand is, for ordinary resolution, it is simple majority. Meaning what? Listen to me. Number of votes cast in favor exceeds number of votes cast against, if any. Number of votes cast in favor means whatever the number of votes cast in favor exceeds, means greater than sign, is more than, not equal to. It should be more than. Should be not greater than or equal to, greater than. It should be tipping the scale. If 5 votes are favor, then 4 votes are against, 1 vote extra. That 1 vote extra should be there. Only then the number of votes cast in favor should be more than the number of votes cast against. In that case, it is called ordinary resolution. Only, I'm answering now the question raised by Preeti ji, which is who will pass ordinary resolution? Members only will pass ordinary resolution. In board of directors meeting, there is no question of ordinary and special. Simple majority, that's all. And that to 1 person, 1 vote. Whereas in members meeting, 1 person, 1 vote. Then if it fails on a poll, 1 share, 1 vote. Right? Whatever may be the voting pattern, number of votes cast in favor is more than the number of votes cast against. Simple majority ordinary resolution. Now listen to me. This is very, very important. This is very, very important. Special resolution. Number of votes cast in favor. If you want to write it down somewhere, please, as I'm talking to you, please make a note of it. Number of votes cast in favor is not less than 3 times the number of votes cast against, if any. Number of votes cast in favor is not less than 3 times the number of votes cast against, if any. Please remember the words exactly as I have told you. Because somewhere in your earlier education, they might have told you 3/4 majority, 2/3 majority, 75%. Special majority means a majority in special circumstances. All sorts of nonsense would have been told to you. Please unlearn all that. Please take away all that from your mind. Take away all that from your mind. Now, tabula rasa, clean mind, fresh mind, wipe it. Now, once more I will repeat. Write it down. Lik dijiye, please. If you don't believe me, verify. Go to section 112, verify. Don't believe me. If you don't agree with me, don't waste your time in query pad arguing with me. Go to the section. Okay, read it. There you will find in similar form. There will be more complication, which I'll come to when we come to management administration. Right now, what is the special resolution? It is passed by the members. How? The number of votes cast in favor should be not less than 3 times the number of votes cast against, if any. So if the number of votes cast against is 1, then number of votes cast in favor should be at least 3. At least 3. If number of votes cast in favor is 2, then number of votes cast against is 2. The number of votes cast in favor should be at least 6. Okay. Here's the question. If number of votes cast against is 0, if number of votes cast against 0, then, in fact, if I give this as a proper question, you will understand. Madam Preeti Verma, hello, folded arms, member, shareholder, alag nahi, both are one and the same. Board of directors will pass board resolution. Members will pass ordinary or special resolution. Member or shareholder, both are one and the same. Member, shareholder, one and the same. Member means his name is entered in the register of members. Shareholder means he's holding shares. Otherwise, the same. So it's like similar. Not exactly same, similar. So when I use the word member, you can say it is synonymous to shareholder. So resolutions of members or shareholders are called ordinary or special. Whereas board of directors is the board meeting, that is called board resolution. So your statement that members pass ordinary resolution, shareholders pass special resolution is not correct. Please remove it. Also, my definition of special resolution, please, yaad rakh dijiye, please. I finally ask you one question. I'm not going to expect an answer from you now. When we come to management and administration, we will do it again. But now just ponder. Suppose 5 members are attending. 5 members are attending. 5 members are attending a meeting, right? 2 members, 5 members are attending. 2 members for, 2 members new. 5 members are attending. One member passes for. One member for. The balance 4 of them. One member for. Balance 4 of them neutral. They don't vote. They neither for nor against. 4. 5 people attend. 1 person for. 4 neutral, abstaining. Have I passed a special resolution? This is the whether you have understood the topic or not, this is the real proof. Special resolution, whether you have understood, this is the proof. 5 members attend. 1 is for. 4 abstain. They don't vote. Not against. They don't vote. 0. They don't vote. Neutral. Have I passed a special resolution? It will be like you say no, but how you should approach it, Agashji? Think. Where is the beginning? Number of votes cast against. How many votes were cast against? Not 4. 4 are neutral. They are not against. So number of votes cast against is 0. Now, my knowledge of arithmetic or mathematics is still correct, I hope. 0 into 3 is still 0 only now. And 1, even though they have not changed the mathematics, I hope, 1 is greater than 0 now. See, that is why this topic is not easy. Correct. Sadab got the point. You had passed because it is more than 3 times of against as against is 0 and 0 into 3 is 0. See? Boss. So that is why I'm saying note it because it is easy to get confused. This question was asked in the exam once, the way I'm asking it. Maybe the numbers would have been slightly different, but topic was asked once. Okay. So, correct. You got it? Yeah. Many of you will think it is not because it sounds so dangerous now. 4 people neutral, 1 only for. Can I say it is a special resolution? No, because all along you have been your brain has been further confused by succession of teachers in wherever they taught you this topic. They said 3/4 majority, 75%, 2/3, all wrongly they have given you. Suddenly for the first time in your life, true knowledge comes to you. I hope. Okay. And therefore, it is a little frightening. Don't get frightened. True knowledge will always be frightening. It is only all that stupid, stuff, coaching notes and all that stuff will be easy to understand. Whereas to understand the true knowledge, to become a professional chartered accountant, you need to understand the BAR Act, the law as it is, not as given in some textbook and all. Okay, you go to management and administration topic in our institute ka material. Our institute ka board of studies ka material, you will trust na. You will not trust the BAR Act, but you will trust the institute ka material na. Go there. You will say what I have told only is there. Okay, because in most cases, our institute ka material will reproduce the words given in the BAR Act, and then they will give explanation for that. Okay, so that is it. See what happened because of this definition of special resolution. We have gone tangentially, but that is okay. Why? Because this topic of special resolution term will keep on coming from now on. Every other section in the Act, you will find special resolution. So your mind will be confused. What is special resolution? What is so? Now you don't have to get worried. Board resolutions hai, which are passed by the board of directors. Other than board resolution will be passed by shareholders or members. Both are same. They are ordinary or special. Ordinary, number of votes cast in favor exceeds the number of votes cast against, if any. Special resolution, number of votes cast in favor is not less than 3 times the number of votes cast against, if any. Okay. If I have repeated this many times, so, sir, language of BAR Act feels very heavy. How to read it easily? Sir, 2 things, sir. 1, read it 3 times, it will become clear. 1. 2, take it and separate it and write it in simple language. It will become easier. Okay, there is no other go. You have to take the trouble. That is why, see, in a way, in my PowerPoint presentation, in my notes, I have taken that complex language of the BAR Act and made it into simplification. That is what I have done. My guru, Professor K. S. Anantaraman, has written a book, Lectures on Company Law, by K. S. Anantaraman. That was a classic example. He took the BAR Act, the complicated language of the BAR Act, and he made it into a simple. I have also tried my best to convert the complicated language of the BAR Act into simple. Wherever possible, I have read the BAR Act thoroughly. Wherever possible, I have reduced it into simple English, diagrams, etc. So in a way, if you follow my lectures and also my the PowerPoint presentations, you are safe. Should I write the exact wordings of the BAR Act? No need, sir. So long as you should not make a mistake while writing in your own language. Are you able to understand? That you should be very careful. Certain words are very important. Those words should come here also. Other than that, you can use your own simple words also. Okay. So, in fact, for example, see, procedure for alteration of name class I have given as a diagram. So, what you need to write in the exam? In the exam, they will never ask you a question. What is the procedure for alteration of name class? Rather, they will say, so-and-so limited had this name. Now they want to change it to some other name. Advise the board of directors on the procedure to be followed. This is how the question will be asked. But basically, it's a procedure alteration. So basically, you have to say the company should hold a general meeting and the special resolution should be passed for alteration of the name clause in the memorandum. Thereafter, they have to apply to the central government in form number INC 24 and obtain the approval of the central government in writing. The name of the company cannot be changed unless the approval is required. However, then once you have written this point, then you should write, however, no such approval shall be necessary, and the only change is the addition or deletion of the word private on account of conversion. Because for conversion, it is only alteration of articles. But remember, for alteration of articles, you will need to pass a special resolution there. But there is no need for getting approval of central government in writing. Where you are converting public to private or private to public, there would be a special resolution required. There would be number of special resolutions. Amendment of a memorandum, name clause, amendment of article, name clause, removal of those 3 points from the articles for a private company to make public company, all that. But no need for getting the approval of central government. But suppose you want to change the name of the company itself. For example, I had a company which for consulting, which was called Blue Dot Corporate Solutions. So about 4 years ago, I wanted to change it from Blue Dot Consulting Solutions. We changed it to Prometheus Consulting Solutions. So all the paperwork was done and the name was changed. Now the company is called Prometheus, including this application in INC 24, wherein we obtained the central government approval, all that. So I think I have it somewhere. I'll try to show it to you also if you want. And so then thereafter, once the approval is given by the central government, that is the Ministry of Corporate Affairs, the registrar, will issue a fresh certificate of incorporation. And the new name of the company will be noted in the Register of Companies. The Registrar of Companies has a Register of Companies. So your new name will be noted in that. Okay. So the new name will be entered, and you will also have to put formerly the old name for at least 3 more years. In case you have not filed your annual return or the financial statements, or you have not repaid mature deposits or debenture interest, then change of name cannot be permitted. But once you file all this and do everything correctly, then name change will be allowed. Do you notice the reason? Suppose your name is Dubacor Limited. You have obtained fixed deposits and all. Now you want to quietly run away. So you want to change your name to, Fortune Limited. Sorry. You repay all your depositors first, then come to me, we will change your name. Because many people will be thinking Dubacor Limited. Suddenly they're Fortune Limited. So they may be cheated. Therefore, you can't change the name unless they repaid the deposits and debentures with interest. So in some cases, what could happen is Section 8 company, anything if you want to do, you should get the approval of central government. Please remember, that is not under this section, but under Section 8 itself. Any change in the memorandum and articles of a Section 8 company, straight away you have to get the approval of central government. That is the regional director. Okay, you will come directly under his control. Because you see, he is giving you a license. One of the conditions of that license is you will get his approval before you amend your articles. So there will be dual provisions. One under Section 8 plus under whichever clause you are going. Got it? So there will be 2 provisions you have to comply with. In Section 8 company, there will be dual commitment. Because Section 8 itself they have to do with the regional director. So remember, Section 8 companies are closely monitored by the regional director. So it's quite possible that, at the time of incorporation, the registrar might have allowed you to be incorporated with the name which is identical with or too nearly resembling the name of existing company. Okay. Now, or the name is identical with or too nearly resembles to an existing trademark. See, the proposition 2 there is there in the Bar Act, but normally, in English, that proposition won't come in this context. So, too nearly resembles the name. So, too nearly resembles to the name is more of a vernacular translation to English. That proposition won't happen in English. But unfortunately, it is there in the Bar Act. So, I'm including it there. But proper grammar of English grammar, it is wrong. Okay. So, that way the Bar Act is very ungrammatical also between you and me. As the Companies Act 2013, for you are saying it is tough. For me, I'm saying it is so ungrammatical, I literally weep and cry when I see the bad English. But that's okay, what to do. So the point, that's why I put the 2 in bracket, but if you see the Bar Act 2 will be there. So I've given it to you. But the sentence reads perfectly grammatical even without the 2. In the opinion of the central government, is identical with or too nearly resembles the name by which a company. In the earlier law, it was clearly like that. I don't know why the 2 was now introduced. Anyway, because English itself is a very stretchable language. like Hindi, both these languages, grammar-wise, they can be stretched a lot because they are both, Hindi and English have this commonality. They are not original languages. Unlike Sanskrit and Tamil, which are original, they are called original language. Chemmoli we call. Sanskrit is one, Tamil is one. Tamil is one, along with Arabic and Chinese, Hebrew, okay, Greek, Latin, of course, and Sanskrit, Tamil, Chinese, Hebrew. These are the original languages, accepted original. English is not an original language. English is a hybrid language, derived from Latin, French, German, Scandinavian. You'll find so many languages are mixed in English. Similarly, you'll find Persian, Urdu, Pali, Magahi, okay, Bhojpuri. So many languages have got merged into what we now call Hindi. Okay, just for your information. If you don't believe me, Google it, you will find. Hindi is a amalgamated language, which is why the original Magahi, the original Bhojpuri, the original Meithei, they are gone. Nobody speaks these languages anymore. Thanks to the great Hindi, nobody speaks Magadhi now. Nobody speaks Meithei, or at least they speak it, but they don't even have a written literature in these languages. So it's unfortunate that we lose all this. Anyway, now the point is, if the name of a company is identical with or too nearly resembles the name by which a company in existence had been previously registered, or is identical with or too nearly resembles an existing trademark. See, you might ask me, sir, name, okay. I incorporated a company with the name Reliance, whatever, Reliance Enterprises Limited. Definitely Mukesh Ambani will get angry with me. But how the trademark, sir? What is wrong? Trademark is not the name of a company. It is only trademark. But believe me, under the international agreement we have signed in the UN, we have agreed to protect trademarks, whether originally as a trademark or as the name of a company. So if you want to incorporate a company like Nokia Enterprises Limited, sorry, cannot be done. Nokia is a registered trademark in India. Now, how do you find out? There is something called that, just like you have register of companies, you have a register of trademarks. You have to go there and search whether similar mark or name is there with similar wordings is there. Obviously, you can't do this. You will hire a trademark attorney who will revert back to you and give you a report saying, hey, these companies look similar to your name. These trademarks look similar to your name. So then you have to be careful. Okay. But by and large, the minute we see the name, we'll know whether it's possibility there is a confusion and things like that. Okay. Whatever it is. So suppose normally the registrar will not allot the name. Because before allotting the name, they will do a search of the register of marks. And they will do a search of the register of names of companies. And if they find that, in fact, they don't do it. It is done by a bot. It's done by a program. And the program will compare, check, and then it will throw all these are resembling trademarks. These are resembling names. Now, of course, they will use their intelligence and say, hey, this is not too nearly resembling. Or too nearly resembling. It's okay. Distant resembling. For that, there's a separate, so rule 8 is there. Clearly, what are resembling and all that. Whatever it is, in spite of all this, a company has been incorporated, sir. Now, you are the registered proprietor of the trademark. Then, within 3 years of incorporation, you have to file a complaint. Then, the registrar you will report to the regional director. See the word central government here is the regional director. I've given clearly in the bottom of the slide. Central government is regional director. So the regional director will pass an order. Once the regional director directs you to change, you have to change within 3 months by passing an order resolution. If you fail to do that, then the regional director himself will change and he will allot a new name to you, whatever name he wants. That's all. The new name will be entered. If you want, you can change that new name, but you can't go back to the name which you originally wanted. Okay. Change in the registered office, again, quickly to tell you, within the local limits, only board resolution is needed. Then file a form, ANC 22 with the registrar. Outside the local limits, but you're going from one city to another city, same ROC, meaning Chennai itself. You are moving from Chennai to Chengalpattu, same ROC, no problem. Pass a special resolution, notice to ROC. Gujarat, you are moving from Ahmedabad to Vadodara, Baroda, no problem. Same ROC, enjoy. Only special resolution, file a notice. I want to move from one ROC to another ROC. This can happen only in two states, Tamil Nadu and Maharashtra. So I want to move from Mumbai to Pune or Pune to Mumbai. No problem. Here you have to apply to the regional director. And the regional director has to confirm it within 30 days. Then the company will file the confirmation with the ROC where they are now controlled. Then the file will be transferred. Within 60 days, the ROC will transfer. Then the new ROC will register and certify the registration within 30 days. Between them, it has to happen. Then the new certificate will be issued by the new ROC. That's it. And you have to, that certificate is a conclusive evidence that all the requirements have been done with respect to change from one ROC to another. Okay. Now you want to move from one state to another state. You want to move from the state of Maharashtra to Gujarat, or from Gujarat, you want to come to Bombay, Maharashtra. No problem. You have to make an application again to the regional director in form INC 23. See, earlier it was with the tribunal. Now they said it's okay if the RD itself can handle this. So you go to the RD. Then you have to pass a special resolution for amendment of MOA. Please note there are two special resolutions. One for shifting from the local limits of the city, town, or village, right? And since you are now changing state, your memorandum has to be changed now. Here, this will involve amendment of memorandum by passing a special resolution. Okay. Then disposal of application by RD within 60 days. Before doing that, the RD should satisfy that all creditors are not affected, that there is no objection, whether income tax department, GST, everybody should get NOC. Only then he will allow you. Once everything is cleared, RD will pass an order and a company will file a certified copy of the order of the RD to the ROC of each state. Then they will move from Gujarat to Maharashtra or whatever they want. And once both the ROCs will register and the ROC of the destination state will issue a fresh certificate of incorporation stating that this company is now domiciled in the new state. With that, over. See, these are all popular questions in the exam. These are procedural questions where they can ask you. This is one more interesting provision. With this, I will conclude and go to prospectus. Basically, when you are amending object class, some of the members may not be interested. See, when you are amending the object class, you want to change the object, you have to pass a special resolution. Now, once a special resolution is passed, the object will be changed. But suppose you are a company which has raised money from public through prospectus. So you have issued a prospectus to the public and the public have applied for shares and you have taken money from the public. At the time of issue of prospectus, now you would have told what is the object now. Based on that only they gave the money to you. Now, after getting the money from them, you want to change the objects. Then a special provision is applicable. You have to get again a special resolution for this purpose passed through a postal ballot. Means you have to, in addition to amendment of the object class, you have to specifically tell them, we want to change our object class. Originally, we went for this. Now we want to change. We told you that we want to set up an IT company. Now we want to not to form an IT company, but we are going to use your money for issuing Bitcoins. We are starting a Bitcoin company, whatever something they say. No. If that special is, and it should be through postal ballot. Postal ballot means instead of coming to the meeting and voting, sitting at home, he can vote for or against and post it back. So all the votes will be received through post, counted. So it makes it easy for the member to vote. Okay. Postal ballot, which is a great thing that happened. This happened not by 2013 law. It already happened in 99 amendment itself. Postal ballot is very old and it has created so much benefit. Today, postal ballot is not there. Today, what they do, they send you the notice by email to your registered email address. And then they give you the option to vote through a link, hyperlink. Once you go to the link, you vote for it. Even easier than postal ballot. And cost is cheaper. Email, you have to watch your email. It will come to you. Immediately you go there, click on the link, go to the balloting site, ballot, yes, no, yes, no. There will be a special user ID password which you will get. Only that has to be used. That's it. You vote and come. today. That is called e-voting. Earlier, postal ballot was popular, but now because of advancement of technology, e-voting itself is possible. Okay. Whatever it is, you have to get a special resolution passed. And the details of that special resolution should be published in the newspaper, so that even an uneducated man like me who doesn't know company law, he will read newspaper. That too in English and in vernacular language. So if it should be in Marathi. So I'm sitting in Nagpur and I don't know English. I know only Marathi and Hindi. So I read Hitavada. Oh, in Hitavada I see the advertisement. Immediately I'll go to the my mail and I will go and link and I will pass against. So if the special resolution is not passed, then that they cannot do that. They cannot change the object class. Because suppose a special resolution is passed, even then, those shareholders who are dissenting, means dissenting means not agreeing. They say, we don't want, we gave the money to you for one purpose. We don't want to be with you now. Then they will be given an opportunity to exit, meaning the promoters have to buy their shares out. Own money have to put and take it out. This is the greatest deterrent. And it's a good provision because it protects the investors who have invested their money based on the original object. See, here, in a way, Indian law is going beyond the doctrine of ultra vires. They are making it not possible for the company to do anything ultra vires. Even to change the object, they are saying they have to get special permission from the investors. And if the investors don't want, they can walk out. See, suppose 40% of the shareholders are dissenting and they say, give me my money back. Even the promoter will start thinking, why should I do this, and stop doing it. So this is as I told you, with this, I have come to the end of this topic. Now I will be starting a new topic. In the meantime, if you have any doubts on this topic, you can raise it. I will now go to prospectus, which I will finish by 8 o'clock, inshallah. After which we will maybe have question answer. I don't know. Seriously, this new format is a little difficult for me to grasp, but yeah, Ms. Gopal Mittal is asking approval of central government. See, the word central government is a wide term, madam. It is like central government could be the ministry itself. There could be an undersecretary or director or somebody there. Or it could be the regional director. By and large, about 90% of the time, 95% of the time, in the Companies Act, if you see the word central government, it will be regional director only. You have to take it from me. Wherever necessary, while teaching sections, we will tell you what is the. Otherwise, there is a circular issued by the ministry, wherein they very clearly give for the purpose of each section, what is the central government. So normally it is regional director. Okay, not the ministry. And here the central government is not Ministry of Finance. Oh, no. There is a separate ministry for this, Ministry of Corporate Affairs, MCA. They're all afraid of them, Ministry of Corporate Affairs. So there's a separate ministry. Ministry of Finance, where they give the budget and all that. In many cases, the Minister of Finance will also be the Minister of Corporate Affairs, or basically the Ministry of Corporate Affairs will come almost under the control of the Ministry of Finance. But why? Because earlier, the Ministry of Corporate Affairs was actually a Department of Corporate Affairs. That department is there was part of the Ministry of Law and Justice long ago, before 90s. Then suddenly they found, hey, these fellows are collecting a lot of money. So once they said, you are now a revenue department, therefore you come to Ministry of Finance. So the Department of Company Affairs went under the Ministry of Finance. Then it became so important, and many successive prime ministers found there was a need to have company thing and all, reforms and all that. So they said, have a ministry for it. So they have a separate minister now. Many cases, the Ministry of Finance Minister will become the Minister of Company Affairs. Or they might have one guy there, but basically coming under the control of the Ministry of Finance. So there's a separate ministry there. See, Mr. Akash, it is not possible for me to use Hindi. Why? For the same reason, you cannot use Malayalam or Tamil. You cannot speak Tamil now. Can you? You cannot speak Malayalam now. Similarly, I cannot speak Hindi. Okay. Thoda hai, but very little. I cannot fluently speak in Hindi. I know it's a crime, but what to do? And I'm very clearly informed by my appointment letter that I should speak only in English. Are you able to understand? I'm not allowed to speak in any other language. Forget Hindi. Any other language. Even if I speak in Malayalam, out. I cannot. So you understand the situation. Kindly bear with me. Okay. You have to learn from a teacher who does not know Hindi. Kindly get used to that concept. Is it possible? Huh? So many, more than 20,000 students in Tamil Nadu, Andhra, and Kerala have learned from me. Luckily, they were not insisting that I should speak in Telugu or Malayalam, which I don't know, okay, or Kannada. They were willing to listen to me in English. So now, unfortunately or fortunately, a pan-India audience, 100% in the first two classes, student will ask Hindi. I will also explain. Once I got an Hindi request, I ignored it. But Akash, you seem to be a very, interesting student and who likes to ask questions now. So to you, I'm humbly suggesting, please don't put this message again. Because unless some divine influence is there and God comes to me and in my tongue they write Hindi, I cannot speak in Hindi. So an inability to speak, kindly don't put it against me. Okay. I will also not hold it against you for not being able to speak in Tamil or Malayalam or Telugu and all. Obviously, because that is not your mother tongue. Similarly, I cannot speak in Hindi. So kindly bear with me. But I will speak in English, very simple English, Asan English, which you should also try to learn to understand in your own interest. What do you say? So don't get into the, please, fold the arms begging. This is not about Hindi not being important. Hindi, bahut important hai. Please, but this idiot cannot speak Hindi. But he can speak English and he knows company law. The choice is yours. Learning from this man who cannot speak Hindi but knows company law, or forcing him to speak in Hindi but I'm not listening to him if he does not speak in Hindi. Sorry. Knowledge or language, you decide. This knowledge will come to you in English, which I can speak. Okay. So this is the end of this Hindi issue. And again, I'm telling with folded arms, Hindi, bahut important. Hindi is the most important language in India, etc. Luckily for me, I never had a reason to go beyond Vijayawada. So I never, English was enough. Even when I went north, thoda Hindi was there and English was there, I managed. I travel all over the country. Right up to Kashmir, I have traveled. Right up to this side, Wagah border, I have traveled. Right up to Gandhidham, I have traveled. This side, right up to Burma border, I have traveled. Mukukchang, I have traveled. With my little Hindi, I have traveled. Okay, so bear with me, Akash. Bear with me. This is the last time we will talk about language. I hope. Okay, if you can understand English, please, I'll be happy. I will try to use as much Asan English as possible, simple English. Especially there are many English words in the law which need to be, you will need to understand. There I will tell in, so I will tell in English. Yeah, of course, not knowing Hindi is a crime, but I plead guilty and I'm ready for my punishment, which I have already been punished. Financially, I've been punished. As a trainer, as a corporate trainer, I've been invited so many places. Gurugram, about 50 lucrative assignments I have lost because they said, Shrikantji, you are too good. We want you to come and train our people. Please, sir, can you speak in English? Hindi. I'll say, sorry, ma'am, I cannot speak in Hindi. I can do in English. No, English. And I'm talking about GM, sir, and assistant general managers and general managers training. There they will say, please, Mr. Shrikant, sorry, because they would have seen me somewhere else and been impressed by my training. But they want me to come and train their people, but language. So I've lost that lucrative, though of course I earned crores below the Vindhyas, I learned crores. But beyond the Vindhyas, I could not come because of my inability to speak this wonderful language called Hindi. No problem, no regrets. Okay, no issues. Coming to the point. Prospectus and allotment of securities. Two parts are there. One is called public offer, the other is called private placement. Public offer means instead of sending a letter to people individually by name, you are making an open advertisement. General offer you are making. Okay, or general announcement. I'm not going to use the word offer. Though the word offer is used here, this is not the same offer meaning as in Contract Act. Because when you issue a prospectus, you are only making an announcement. When you issue a prospectus, you are only making an announcement. Okay, you are telling we are offering these shares. If you want to buy, buy. When the application is made by the public, then they are making an offer. When I allot the share, then acceptance. Share comes into existence, offer, acceptance, contract between the company and the member. And the members interesting. Okay, so this is the concept. 23 to 41, public offer. Only one section, private placement, safe but important. Okay, so what we'll do, we'll quickly see public offer, prospectus issues, salient points we'll see, then we'll see private placement. Ajto, I think that's all you can do. Let us see. So that then half an hour I want to give for questions. Okay. So, okay. In which section there is provision relating 21, I think. 1 second. Conversion of private to public and public to private, 21. I'll check up and I'll take it. You can convert anything into anything. Let's see. I have it somewhere here. 1 second. Since the question is asked, let me quickly go there and do it, because see, when you're asking a question from a main area, I still have to answer you. Give me 1 minute. Intermediate incorporation. This is the biggest. See, this is the bigger PowerPoint, which normally I would have used in my 2.5 day session, wherein you will find everything is there. Somewhere. So even though I don't know Hindi now, I will try to talk as if I know. This is section 8 conversion. You have normal conversion itself. I'll come to that. You will find it in alteration of articles. One second. I think 21, if I remember right. I'll just go there. Change in list office. We saw all this. Alteration of articles. Procedure for conversion of private company to public company and public company to private company. Provision relating to conversion of public company to private company, private to public. 21 was the old section. Yeah, sorry. See, Buddha hai na, so I'm still remembering the old section. Old section was 21. New section 14. So this is the rule for conversion of private to public and vice versa. Okay, section 14. Okay. Alteration of article, section 14. In that, one of the alteration could have the effect of conversion of public to private and private to public. Then the procedure is laid down here. Okay. So 14. Okay. Section 14. You have to remember that. Section 14. In those days, it was in section 21 of the old law. That's why I remember that rather than this. So to answer your question straight away, in which section there is provision in relation? It is 14, section 14. Yeah, Akash, as I told you, though there is only one section, regularly questions will be asked in private placement. So I will cover that 100%. Yes, sir. See, Vamsidharan sir, where if you are a dissenter, if you do not like change, then even though See, in the resolution, you might have voted for. No, in the resolution, you should have voted against. Okay, and you should go and tell the tribunal, we don't want. Then the company has to buy back your shares. No, not the company, the promoter will have to buy your shares. Or whatever, the tribunal will decide whether the promoter will buy or the company will buy or the money will be refunded. See, normally, remember, here is a case where the shares have been allotted. Are you able to understand what I'm saying? The shares, if the shares have not been allotted, yes, you can refund. But if the shares have been allotted, then refund is not possible. The shares have to be either purchased by the company and written off, cancelled, or the company will have, they will have to go for, the promoters will have to buy. Okay, so the slight difference, whether at which time it happens. The allotment has already happened, then company has to either buy back or they have to sort of ask the promoter to buy it. Tribunal will pass an order. In this case, the law doesn't come to your head. Everything will be decided finally by the tribunal only. Whatever the tribunal, because facts and circumstances will be different. Therefore, based on each fact, in fact, if it comes to a stage and this matter becomes such a big thing that the tribunal is totally unhappy with this whole thing, it can even wind up the company on the grounds that it is just and equitable to do so. That much power the tribunal has. And once the winding up happens, everybody will get their money back. That's a bush. So actually, this section is meant not for implementation, but for deterring. The minute this section is there, if any promoter tries any stunt, the company secretary or the chartered accountant like me, the auditor, somebody will advise him, boss, don't do this, dangerous. If you change the object now, if anybody dissents, will you buy back their shares? Oh, is it so? I have to buy back. Why should I buy back? Like then, initially the promoter will talk all nonsense. But once you show him the section, boss, this is what it is all about, then he'll keep quiet. See, in the exam, if I'm setting a question, you know what I will say? So-and-so company took money like this. Then the MD, some Mr. So-and-so arrogant, wanted to change the name. And he says, please advise him on the consequences. Then you have to write what will be. He can also say, out of this, so many shareholders are dissenting, like that. In which case, kindly advise him. Then you have to clearly tell him, Baba, you have to pass a special resolution. And if that special resolution is passed also, the dissenting fellows, you have to pay. Are you ready? If you are ready to pay, then we'll go ahead with your amendment at all. Okay. So that is the point. One more thing I'll tell you. Institute examination is not about mugging up and vomit. It is about understanding the principles of the law and the fact and the content, not just the principle, the content, the content of the sections, in such a way that you will be able to apply these sections to the given situation. To a given situation, you should be able to apply the section. Not only in company law, income tax also. Remember, income tax is also a law. So there again, you should know how to apply. Except that there more computational aspects are there. Whereas here, the computational aspects are less. So otherwise, both are application of law. So you should know which rate to apply, which amount to apply, what is the limit, etc. Everything is in the law. Given situation, you have to apply. Wonderful. Moving on quickly. So basically, public company only can make a public issue, public offer, initial public offer, further public offer, offer for sale. Public company can also go for private placement or a rights issue or a bonus issue. Whereas private company cannot go for public offer. It can only go for private placement, rights issue and bonus issue. Okay. So there can be no listed private company except where a private company issues debentures secured. Such debentures may have to be NCDs and non-convertible debentures will have to be listed as part of the condition for issue of the debentures. In which case, debt instrument alone will be sometimes listed for a private company, but that will not make the private company a listed company because the shares of a private company can never be offered to the public. Therefore, it can never go for public issue. If you want a private company to go for public issue, first you have to convert it into a public company. Convert it and then go public. So please don't let this doubt ever come into your head. Can private company go for public issue, sir? Never. How to go, sir? Private company must first become public company. Even, for example, when a private company becomes a subsidiary of a public company, it will be deemed to be a public company. Now, even such a private company, please note my words, even such a private company cannot go for a public issue because its articles will contain the prohibition only for the purpose of application of the law. Which provisions of the law will apply? It will be treated as if it is a public company, but it cannot go for a public issue. If it wants to go, then it has to remove those conditions in the articles, change its name, remove the word private, and then convert itself into a public company according to section 14, which we saw now, and only then it can go for public issue. So please do not have any, these are all why I'm asking these doubts now. These are all queries raised by students and sent to me by Board of Studies for answering. Therefore, I am myself raising this query and answering it for you. Some intelligent students have raised queries. Some intelligent, some not so. But the queries have come. So these queries are now being raised by me and answered for you. Okay, prospectus is a wide document. It's widely defined. It is defined as any document issued or described as such. Okay. It includes red herring prospectus, shelf prospectus, and all. What is this? We'll come to it. Don't worry. I will tell you very shortly what is red herring and what is shelf. It includes any notice, circular, advertisement, or other document inviting or offer from public. The minute you send in even a circular saying Debentures Limited offering shares or Debentures Limited will issue its shares, anybody interested can use the application and apply prospectus. Why we are making so wide now? To prevent unscrupulous people from collecting money from the public. Because, sir, you are all highly intelligent chartered accounting students here. Ordinary people like me are there who don't know anything. So how do we know what it is? We see something, yes, Debentures Limited, I will become a member like that. So they want to punish these people. So they say, even if you send a notice or a circular by which you are offering any shares to the public, it will come under the head prospectus. And which the minute we say it is prospectus, the format of the prospectus is prescribed. Only that format should be used. This is the format prescribed by SEBI. That format has to be used. No other format is allowed. You cannot write one of the best companies in the world. Our MD is the greatest human being. Sorry, all that is not relevant for me. What is your last 5 years P&L? How much profit have you made? What is your projection for the next 5 years? How realistic is it? What industry are you in? What is your market share? In that industry, where are you? Who are you? All these unfortunate and uncomfortable questions will be raised in the prospectus. You have to answer. Okay. Therefore, any notice, circular, advertisement, document which says we are offering shares to the public will become a prospectus. So, the date of the prospectus is very important because the date indicated should be deemed to be the date of the prospectus. Why? Because before issuing the prospectus, you should file a copy with the registrar. So, if a prospectus is issued even one day before it has been registered with the registrar, it is a violation of the law. Prospectus should be signed by every person named therein as a director or proposed director. See, if you are saying in your prospectus, our directors, board of directors includes Mr. Donkey, Mr. Monkey, then finally Shah Rukh Khan proposed. That is, Shah Rukh Khan has not become your director. You are saying he will become director in future. Sorry, if that is so, then Mr. Shah Rukh Khan should sign the prospectus. You can't simply put his name, misuse his name to get money from the public. Are you able to understand? Many times, celebrities will be misused, their names, by unscrupulous people. So if you are putting Shah Rukh Khan there, no problem. If he is interested, yes, please, but get his signature there. Okay, so register not to register unless all complaints are over and all persons named in prospectus are filed their consent in writing. So this is a very, very fundamental condition. Unless you do this, the registrar will not touch the prospectus. He will simply ask you, have all the signatories, the persons named therein given their consent, show me that first. Everything there. Signatures will be verified, etc. and kept. See, tomorrow if that celebrity wants to say, I didn't aware of it. sorry, please see your consent has been given in writing. Okay. Now, the only way they can escape is by saying that they gave the consent and withdrew it, but before the issue of prospectus. Okay. So prospectus should be dated and signed and all that. Also, if any expert is giving his opinion, such an expert should give his consent and should confirm that he is giving it as an expert. Okay. Once a prospectus is delivered for registration, it is valid for 90 days. Within 90 days, it has to be issued. Beyond that, you have to issue a fresh prospectus after getting it again approved by registrar and filing. So I'm giving only this penalty provision. All other penalty provisions I'm not giving. They are there in the main lecture. Here I'm not giving, but in this one case I'm giving you because this is a very, very powerful penalty. Any violation, the penalty is company 50,000 up to 3 lakhs. Any person knowingly a party to the issue of prospectus, including company secretary, CFO, everybody, fined 50,000 to 3 lakh. Earlier, imprisonment was there. Now there is no imprisonment, luckily. Okay. So there are many types of prospectus. One is called shelf prospectus. See, basically it's like this. I'm going to issue a series of securities. Classic example is debenture. Boss, I need totally 200 crores. But that 200 crores is needed for a project which will be undertaken over 3 years. So at one point, I don't need 200 crores. So what I'm going to do, I'm going to take this 200 crore in 4 tranches, 50, 50, 50 in 1 year. So by the end of the first year, I want to take 200 crores in 4 tranches or maybe 6 tranches, 1.5 years. The idea is that I want to complete it within 2 years, but maximum over in 3 years. So first time I want only 50 crore. Okay. Or maybe I will take 200 crore in, say, 5 in tranches, whatever, 40 crore, 40 crore. Point is, initially I want 50 crore. So I will issue a prospectus. This prospectus is called shelf prospectus. Okay. At the time of issue of the prospectus itself, I will say it is a shelf prospectus. Once I say it is a shelf prospectus, I have taken 50 crore in January. Again, in April, I want to take another 40 crore. I don't have to issue a fresh prospectus. This old prospectus and a shelf prospectus that will be valid for a period not exceeding 1 year. So from 1st January to 31/12, the shelf prospectus will be valid. So from the date of opening of the first offer of securities, it will be valid for 1 year. So within that 1 year time, I don't have to issue first prospectus for new series. So first 50 crore, then 40. Then again by September, I can take another 50. So totally 50, 50, 40, 1 crore 90, 1 crore 40. Now, if I don't take another 60 by December, then this prospectus will be out. I have to issue first prospectus. So in between this 1 year, I can keep on taking. Okay. So once you have filed a shelf prospectus, no further prospectus is required during the validity period for subsequent offers. Right. So the shelf prospectus stays on the shelf, as it were, and is always available for the public to view. Suppose after you issue one shelf prospectus, you collect money, you're going for a new fresh issue. You don't have to issue a prospectus. But if there is any material change in the financial positions, material change, that has to be contained in an information memorandum. Only the change will be given. For example, if you have increased the share capital, or if you have repaid a main loan, or if you have taken on some more loan, whatever, that material facts regarding change in financial position should be contained in information memorandum. That information memorandum alone should be filed in Form PAS2, 1 month prior to every fresh offer. So that, let us say I am the investor. I want to invest in the second series of debentures. I will go there. The shelf prospectus will be there. I will read it. Then the latest information memorandum will be there. I will read it. That's all. Doctrine of constructive notice satisfied. I have read all the information. Now I will invest. Right? So the basic idea here is disclosure. So in case I have remitted subscription money and there are some changes in the financial position, after I gave my money, but before the allotment, then I have the right to withdraw my application. So if there is any major change in financial position between the date of shelf prospectus and information memorandum, then in case my shares are not allotted, I can always withdraw the application. Company should refund the money within 15 days. Okay. The information memorandum will be deemed to be a part of the original shelf prospectus. Now there's something called red herring prospectus. Because when it was originally introduced, the concept of red herring prospectus was very, very simple. There was something called book building. The concept was, I am the company, I am going for issue of shares. I am not aware what price to charge. I don't know what will be. See, that's always a very, very dangerous thing. You might undervalue your company or you might overvalue. If you undervalue, then you lose because market price will go up suddenly. See, there are many issues. Post-issue, the share price will go up by 50%, 60%. Those are all undervalued issues, including the famous Maruti Udyog Limited, Viday Sanchar Nigam Limited in those days. Okay, are all under. Similarly, it's possible for overvaluation also, like LIC, which is overvalued, but that's why the price fell. But that is not a problem for the company. But it is not LIC. If it is some other company, if I overvalue it, then the issue will be undersubscribed. Therefore, the company has to assess the demand and price band. For that, what they will do, they will first issue the red herring prospectus. They will first issue the red herring prospectus to QIBs and HNIs, who will send in the bids. Once the bids are received, then the bids will be analyzed. See what is the appetite. And the advisor to the issue, he will advise the company on what price to charge. Now, a proper prospectus will be issued, which will contain the price band and the number of shares to be issued. Okay. So, the original prospectus, which is issued to the QIBs and HNIs, which does not contain the price and the number of shares issued, that is called red herring prospectus, because it does not include complete particulars of the quantum or price. How many shares are to be issued and what is the price at which they'll be issued? It will be blank. That will be decided by the bidders, who are obviously knowledgeable people, QIBs, HNIs. Based on these bids only, the final price will be decided and then proper prospectus will be issued. Okay. The format of the red herring prospectus will be same as the regular prospectus. Later on, when the regular prospectus is issued, the only extra will be price will be known and number of shares. And if any change in the financial position, etc., between the RHP and the actual prospectus, that has to be issued or announced. And in case there is any change, then that has to be, a memorandum has to be filed. In many cases, every application form for issue of prospectus should be accompanied by a prospectus, they said. No prospectus will run into 60 pages. So many companies went and said, sir, how will print, sir? For every application, if you printing cost will be prohibitive. So they said, don't give the entire prospectus. We'll give you an abridged form, alone you give. So the PAS2 form was given. So today, this abridged prospectus is meaningless. Why? Because today, we don't have to print bars. I'll give you a link. You go to the link, you press, it will download. The entire prospectus will come to you as a PDF, download onto your mobile phone or your, laptop. So nowadays it's not, but still, if you demand the printed prospectus, the broker or the company will give it to you. Believe me, I have analyzed many IPOs. I will not even ask for a physical copy. I'll just go to the website, download the prospectus, PDF, go through it. It's as simple as that. Okay. Lastly, you have a topic called deemed prospectus. That is document containing the offer of securities for sale to be deemed the prospectus. Okay. I will do this and then go to private placement straight away. Okay. See, the idea of this is the company, instead of making an offer to the public directly, what they do, they allot these shares to another company or to an agency. Then that agency makes an offer to the public. Now the logic they said was, hey, the company only should not issue now, but we are making the offer now. So how can you say it is the prospectus? After all, I am not the company. I am only another buyer. I am giving it to people. No, they said where the company has allotted shares to anybody and that person is making an offer to the public, then that document will be deemed to be a prospectus. Where the allotment of securities made by a company with a view to all or any of those securities being offered for sale to the public. So how do I know the intention? How do I know whether this allotment was made with a view to the securities being offered? How to find out the intention? There they have given clearly two conditions, either or. See, how do you say we allotted the shares, Dubacor Limited allotted the shares to Runaway Operators Limited agency, financial agents. This runaway operators, they made an offer to the public. How do I say the intention of Dubacor Limited was to allot, to give it, when giving it to runaway shares, that the runaway shares will make an offer to the public? How do I know? Simple. If you're able to show the company allotted the shares to the agency, then the agency made an offer for sale to the public within 6 months after the allotment or agreement to allot. 6 months. So I didn't even allot. I entered an agreement with this guy. Hey, in case you are able to get buyers, I will allot these shares to you. If thereafter the offer is made by the agency, Runaway Operators Limited, within 6 months, that means the intention was there. Within 6 months, he is making an offer. Beyond 6 months, then the presumption is not there. But on the other hand, if you're able to show one thing, see, either A or B, suppose you're able to show that at the time when the agent made the offer, the whole consideration was not paid to the company. Either this or that. Either the offer was made within 6 months or offer was not made within 6 months, but the whole consideration was not received by it. Either way, you can say that this is an offer. It's a deemed prospectus. So you have to ask only one question. First question, has the allottee sold shares to the public within 6 months? Answer is yes. Straight away deemed prospectus. No. Has allottee paid full consideration to company before offer for sale to public? Yes. Then, see, the offer was not made within 6 months. No. And the allottee has paid the full amount. Yes. Then it is not a deemed prospectus. But suppose the allottee has sold within 6 months, straight away deemed prospectus. But you say, no, it was not sold within 6 months. Then we ask him a question. Was the consideration paid before the offer for sale? No. Then also it will become deemed prospectus. See, suppose it escapes the first filter, then the second filter is there. So this PowerPoint presentation, if you look at it logically, you will understand. But if you look at it with the view to finding fault with it, you will not understand. So look at it clearly. Condition A hai, you are satisfying condition A, straight away you come, you don't even have to condition B, you don't even have to go to condition B. But if you still want to test condition B, do it, but no need. Because even if one condition is satisfied, it is a deemed prospectus. So OR is used here. Okay. Both the conditions are satisfied, well and good. Still, it will be only deemed prospectus. Okay. If you want, you can say yes, then one more has already paid. There's no need. Okay. The minute the shares are offered within 6 months, straight away deemed prospectus. If they say no, then you put the second condition. Have you paid the full consideration? If the answer is no, then deemed. If the answer is yes, no, yes, not. No or yes, straight away, or no, straight away, gone. Okay. So the chart is given for you to understand. But if you think the chart is not correct, then please leave it. Good question was asked by Gopal Mittal. Let us see. Validity period. See, it's a good question you're asking, Ms. Gopal Mittal, but I'll tell you how it is. I myself have a doubt. I'll check out and get back to you. Because I want to check whether it is calendar year or financial year. But actually, if it is 1 year, then it is calendar year only. Because surf 1 year, surf year without financial means calendar year. But give me the opportunity to test it once and come. But why calendar year and not financial year? Maybe, I don't know, seriously. Because see, more than calendar year, I think here they are not bothered about calendar year. They are talking about the period of 1 year elapsing between the date of opening of the subscription list and that. So it's not calendar or financial year. For example, today, what is the date? 8th. Okay. So what is 1 year from now? When will 1 year from now be over? Midnight, 7th May 2025. That is 1 year. Are you able to understand? So I don't think it's about calendar or financial year. It is about counting 1 year. So if you have made the opening of the first shelf prospectus now, then opening of the first offer of securities was done today. Then today is 8th now. When will 1 year be over? It's not about calendar year or financial year. When will 1 year be over? On 7th of May 2025. Exactly 1 year will be over. 8th of May, new year will start. Your birthday like that only you are counting now. Every year, same way. So that is the meaning of the word year here. Are you able to understand? Thank you for this. A very interesting question. Good question. I hope my answer was satisfactory to you. So here you are not talking about financial year or calendar year. It doesn't mean that if I make an issue today, on 31st December, it will get over. No. 1 year hai. 1 year will get over only on 7th May. Till then I have time. Okay. Got it? Okay. Good job. But good question. I'm happy, Gopalji, that you have asked this question. That shows that you are thinking. Very good. I'm happy. That thinking skill is important. Once you start asking the right questions, then you will be able to learn more. Good. So moving on, deep prospectus, this is the crux issue. See, I'm going to go directly to our this thing. Private placement. Why? Because as Akash rightly pointed out, in private placement, there are many questions being asked. See, basically, private placement is when you send a notice to a relatively small number of select investors. So the idea is you are not making an announcement to the public. Simple. My daughter's marriage. I'm sending an invitation. How? I will take the cover, specifically write name of my friends and relatives, paste it, put a stamp and send it. Private invitation, private party, public not allowed. Only those people who have the invitation can come. Nobody else can come. Are you able to understand? On the other hand, my birthday party, not my birthday party, some politician ka birthday party, some big politician ka birthday party. Everywhere you will find notice. Our elder brother is getting birthday, a celebration, all are welcome. There is a public announcement. I can just walk in. Because public announcement was, no, anybody can come. Are you able to understand? So private placement means it should be specifically addressed to named people. Nobody else can accept it. Only those people to whom the offer is made can accept it. Please understand, right of renunciation will not be there. Only if I make the offer to Mr. Donkey, only Donkey can accept. Nobody else can accept it. If Donkey is not accepting it, khatam ho gaya, that document is over. Then I have to issue again fresh letter to Mr. Monkey. I cannot, Donkey cannot tell, hey, I cannot take the Sharia, but I'm asking Monkey to take. No, not allowed. Okay. Whereas public offer is different. I make announcement, all and sundry, anybody can come. Okay. And if the obligation comes to me, I have to see whether everything is in order. That is why there is more restriction on public issue. Prospectus, control, consent, content of prospectus. Whereas private placement letter can say anything. Of course, it cannot tell something that is untruthful. But if it is telling something untruthful, the man who read it can file a private suit for cheating. But he doesn't have relief under the misstatement in prospectus. Understand? But still, if the promoters are making false statements, 420 is still there, cheating, IPC is still there. You can file a suit. Or you can file a suit for wrongful representation, etc. But not under the Companies Act, under the general law. So a private placement is different from a public issue. See, the condition is simple now. The offer should be made to a select group of persons. The number of persons not to exceed 50 as per section. Listen to me, very important. In the section, it says 50. Along with that, our great MCA has also told higher number can be prescribed by the central government. Based on this power, central government has prescribed 200. So though the section uses the word 50, the prescribed number is 200. So today, the offer can be made to 200 people. 200 people. They may increase it to 500 also, depends. So 200. Now, for counting 200, QIBs will not be included because anyway, see, QIBs are supposed to play in private placement. They are entitled. As per SEBI permission, they are entitled. So QIBs will not be counted. Though HNIs will be counted. Be careful. Only QIBs are exempted. HNI will come in this 200. Also, employees being offered securities under ESOP scheme. Friends, read every word here. You just don't take employees and ask questions. No. Employees being offered securities under ESOPs only are clear. So don't immediately go and compare this with private company definition and say employee, former employee, blah, blah. Purely current employees. That too, you should have a scheme of employee stock option by which employees of certain category who have worked for so many years are given so many shares. So if I work for 3 years, I get 50 shares. If I work for 5 years, I'll get 100 shares. It is a scheme. And under that scheme, the employees who are now currently there are getting. Then those employees should not be included. Other than these two categories, only 200 allowed. The above limit is to be reckoned separately for each kind of security. For example, I am raising money by way of equity share, preference share, debenture. Then 200, 200, 200. Separate, alag, separate for each one. Okay. Now, an offer for private placement made whether by a listed or unlisted company to more than the number of prescribed above shall be deemed to be a public offer. So even a listed company can go for private placement. Even a listed company can go for private placement. A private company can go for private placement. An unlisted public company can go for private. Whatever it is, if you go for more than the 200, then that document will straight away be deemed to be a public offer and it has to comply with all the provisions relating to content. Also, very important, the private placement offer and application shall not carry any right of renunciation. Okay. It should be approved by a special resolution and the explanatory note or special resolution to provide information, including justification for price and details of value. The value of such offer or invitation per person shall be within an investment size of not less than 20,000 rupees of face value. So individually, each offer or invitation should be not less than 20,000 rupees of face value. Please note, suppose your valuation of your share is 300 rupees, 300, then 20,000, face value 20,000, per share 10 rupees, per share 10 rupees, right sir? Per share 10 rupees. So 20,000 rupees of face value, 20,000 divided by 10. I get 2,000 shares into 300, 6 lakhs. Everybody understand what I'm saying? So 20,000 rupees of face value. So per person, face value is 10 rupees means I cannot make more than 2,000 shares. Okay. So it depends on the per face value per share and also the valuation of the share. Suppose your company is doing very well and has got good valuation, then that much you can collect. Okay. Over and above that 10 rupees, whatever you collect is the share premium, security premium. So board resolution is sufficient for issue of NCDs, where you're only issuing non-convertible debentures, then board resolution is enough. So provided the amount does not exceed the paid up capital and free reserves. Under section 180, which is not in your syllabus, the borrowings of a company shall not exceed the paid up capital and free reserves. So where it does not exceed the paid up capital and free reserves, then board resolution is enough. Where it exceeds the limit, then one resolution should be passed for a whole year. single result, annual special resolution. Enough. You can raise money. So it should be in the format given in PAS 4, serially numbered and addressed specifically to the person. And that person cannot, no other person other than the person so addressed can be allowed to apply. Please note this. Though I use the word donkey monkey, no, don't get angry with me. That's the way I speak. When I give examples, I use donkey monkey. Donkeys are very good animals. Monkeys are extraordinarily brilliant animals. No derogatory comment is intended by the use of the words donkey or monkey. Gardab or bandar, both are extraordinarily brilliant. Better than human beings in many cases. The donkey is such a sincere animal. It works like, with so much faithfulness. The monkey is so intelligent. Chatur. So, no insult is intended for donkeys and monkeys at all. Kindly, if you are a fan of donkeys and monkeys, please, I love these animals. I have the highest regard for them. I am myself devotee of Hanumanji. What more do you want? Okay. Hanuman Kapish hai na? Kapisha hai. Okay. So, no bad intention. Don't believe me? So, I chant Hanuman Chalisa every day. Okay. So, I'm a devotee. So, don't please think I have any slightest insult for these animals. Okay. Because in one class, I told donkey, monkey, one boy got very angry. So, don't use the word donkey, monkey. So, that is why I want to be very clear. So now the company shall maintain a complete record of private placement offers in a register in the format of PAS 5. And very important, please remember this. Please, yad rak. Allotment to be made within 60 days. 60 days of receipt. If you don't make the allotment within 60 days, then the amount has to be repaid within 15 days. Up to 15 days, no interest. Beyond the, you wait for 60 days, boss. Simple. I wanted to raise 2.5 crores. I sent a private placement letter. Finally, I got only 2 lakhs, that too for my brother-in-law. Then that 2 lakhs also has to be repaid only. Okay. Then if I don't allot within 60 days, I can't keep on waiting for money to come. So 60 days, that's all. Beyond that, expired. Refund. Again, you can make a fresh request. Obviously, to new people, keep on doing it till some bakra will give you. Okay, sorry, bakra again is the animal. Sorry. For goat, why should we blame the goat now? But finally, what happens to the goat? Bakrid mein, chak, gone. That is why it's called bakra. So, interest at 12% for delay in repayment beyond 60 days, right? Return of allotment should be filed in Form PAS 3, both for normal allotment under public issue, whatever it is. Whenever you make an allotment of shares within 30 days, you have to file Form PAS 2. For your public-private placement, within 15 days, you have to file Form PAS 3, right? Right? You might ask me, what is this PAS abbreviation? Simple. These forms, in Companies Act, the abbreviation is based on the name of the chapter. So what is the chapter we are now discussing? Prospectus and allotment of securities, class, PAS. Right? As simple as that. Don't get tensed. No? So incorporation, INC, all forms will be INC. Like that. Very highly brilliant of the Ministry of Corporate Affairs to come out with these abbreviations. Okay. No. Money is not to be utilized unless the allotment is made and return of allotment is made. Okay. And no fresh offer unless allotment has been made on an earlier offer orientation or the same has been withdrawn or abandoned. So you wait for 60 days. After that only you can go for fresh. No public advertisement or media publicity begin. Even if one small advertisement is gone, you are straight away, you are bound under the penalty of section 26. Please, that is why I read the penalty of 26, because suppose you make a private placement offer to more than 200, or you make a private placement offer and it's given publicity in the media, straight away, it will be deemed to be a prospectus. Okay. Of course, private placement, you have to be careful. You cannot make a private placement offer, invitation to any citizen or body corporate incorporated in or a national of a country that shares land border with India, like Pakistan, China, Myanmar, Bhutan, Nepal, Bangladesh. Okay. Myanmar is your Burma, Myanmar. Myanmar shares land border. I told you, na, I've been to Nagaland, Mokokchung, where if you walk for another 10 kilometers, you are in Burma, Myanmar, from there. Arunachal Pradesh also has Myanmar border. West Bengal has Bangladesh border. Why? Assam has Bangladesh border. Tripura has Bangladesh border. Bangladesh, we have a lot of borders in the northeast. Whatever. You can't issue these or make a private placement offer to these people. Okay, unless you have obtained government approval under FEM non-debt instrument rules. The idea is whether they are good people or not so good people. So this is your topic. What I will do at this stage, I will stop sharing and I will open the floor for questions like we did last class. Last class, we didn't have much time. Now, I will open the floor. Any questions are there, you can ask me. If you have any questions, you can ask me. Mr. Manish, we will have question answer, sir, in case they want. Yeah. So some are putting on chat, I think. Let us see. Chat, maybe questions there. Got it. So I will read the chat also. Sir, contract related business activity only for sugar company, or if they are sugar company constructing a building, can they become a contract? See, in my example, I gave sugar company and cement company. See, for sugar company, if they are constructing a building, not a problem. Head office, no problem. For so long as that construction contract is for sugar activity. It is only when you're doing it for cement activity that you will be in trouble. Got it? For exception, what if in board meeting investor as a relative? I think it's a very complicated question and I can't answer it. If you want, Ms. Gopal, you can raise that query orally now. Now that you have an opportunity, you can unmute yourself and ask me.
Good evening, sir.
Yes, madam.
Yes, sir. So I had the question that you said ki while in board meeting for doctrine of indoor management, what if investor has some relations in board meeting in which he's investing? So will it be called a doctrine of indoor management or constructive?
No. See, don't confuse like that. Whether it will be an exception to the doctrine of indoor management is what you're asking. Correct?
Yes, sir.
Yeah. Yeah, see, if a relative here is defined in the Companies Act, we saw that in the preliminary topic, right? So those people, like for example, son, daughter, son's wife, and all, if they are there, definitely it's like me being there. So I cannot say that I'm not aware. So even if a relative is there, the exception to the doctrine of indoor management will apply. You cannot claim doctrine of indoor management once your relative is there. Okay. The presumption is that relative is as good as you. So even if your relative is there, it is as means you are there. That is the presumption. Okay.
All right, sir. Thank you.
Okay. So in case of indoor management, if bank has Anup is asking, in case of indoor management, if bank has lent in good faith and directors are in default and filed a suit, will the company suffer or director? See, basically the bank cannot sue the company. Sorry. Once the doctrine of ultra vires is applicable, the bank cannot sue the company. No way. They can only sue the directors for misrepresentation. Whatever they want to do, they can do. But they cannot sue the company at any cost. Okay. In case of indoor management, the bank can sue directly now because after all, as far as the bank is concerned, they honestly believe the resolution was passed or whatever was done was done. They can directly sue the company. They cannot sue the directors because once the company is becoming liable, then directors will not be liable. Unless they have made any false statement or misrepresentation, in which case they can be sued under civil law for misrepresentation and cheating. That is up to the bank to proceed against them. But basically, if the doctrine of indoor management is applicable, then the third party is protected. So they can directly sue the company or file insolvency of the company directly. Okay. Gopal Mittal also confirms that she doesn't create resolutions. Very good. All of us should have only action points, no resolutions. If shares allotted within the time required, then company can utilize the amount from private placement. See, once the shares are allotted within the time required, the form is filed, you can use the money whenever you want. That's all. Once you file the form of allotment within 15 days, that's all. You can use the money. No problem. Straight away, enjoy. Book your ticket to Switzerland. Straight away. Take the money and run. Okay. Yeah, I was just joking. Sorry. Sometimes my problem is I keep joking. Okay. What else? Any other questions?
Hello, sir.
Anupji, go on.
Sir, in case of shelf prospectus, na sir, we receive money in tranches, sir.
Sorry? In case of shelf prospectus?
The money is received in tranches, na sir.
Tranches, yes.
And in case of allotment, if suppose allotment of share is made, company receives in form of application, allotment, and final call. Sir, is there any difference, sir?
No, sir. See, when I make one prospectus, I issue, that prospectus may have partly paid shares and all that. Not a problem. Once I receive the money on the prospectus, I have to make the allotment within 30 days. You understand, no?
Yes,
If that allotment, once it is made, the fact that it is partly paid, it doesn't matter. So, I can make the call later. Your question is whether once I made a partly paid share, whether I can go for one more issue. Is that what you're asking? Is that what you're asking?
No, sir. Are they different or are they similar?
No, tranches. No. They are totally different. I issue a single prospectus in which I issue shares. Those shares are paid in part payments. Is that what you're talking about, Anup?
Yes, sir.
That is totally different from shelf prospectus. Shelf prospectus is I issue one prospectus, I issue one set of shares or debentures. Then, without issuing another prospectus, I issue another set of shares and debentures. Not part payment of these money on these shares. That is a separate set of shares. Usually, Anu, believe me, be practical. For shares, we will never use shelf prospectus. We will only use shelf for debentures.
Debentures.
Yeah. So one series of debentures, they will all give the money over. I will use it. Then another series of debentures, totally new, I will issue. I don't have to issue one more prospectus. This shelf prospectus will be valid for 1 year. Okay. Whereas partly paid shares are different. Single prospectus, one time, shares are issued, but the amount will be received in tranches.
In tranches, yes.
Okay. That is different.
Yes, sir. And in case of red herring prospectus, sir, so that prospectus is issued to high net worth individuals and QI business, sir.
Initially, for bidding purpose. Yeah.
Yes, sir. Can there be any manipulation, sir?
In the sense?
In case of setting the price or...
Sir, manipulation, basically, I'll tell you, there is somebody called the lead manager to the issue, right? Just like as a chartered accountant, you are bound by code of conduct, that lead manager to the issue is bound by a code. At the time of registration with SEBI, he is signing a declaration. Okay.
Yes.
Suppose there is any manipulation, he will go to jail. So that man must be very, very careful. So they will be very extremely careful about how they do it.
Yes, sir. And in case of...
Finally, what manipulation? See, suppose they are fixing a price which is not as per the bid, sir. Whose risk is it, you tell me? Boss, a bid is only an offer, right?
Yes.
I'm making a counter offer now. That's all. Nothing, no illegality about it.
Okay.
And I just finished my point. QIBs and HNI, whether average price comes to 600. Now you want to make it 700. Nobody can prevent you from making it 700. No, but then a QIB has an option to withdraw his bid. He need not accept the share.
Yes.
That is built into the red herring prospectus scheme itself. So once I make the final prospectus, anybody can withdraw.
Yes.
The bids can be withdrawn.
Yes. And in case of private placement, sir, why QIBs are not included, sir, in that 200 limit?
Because see, anyway, I can always go to a QIB and give him a projection, and he may invest directly into me. So there is no need for that QIB to be included in this list. Anyway, QIBs are available for such investment. These are investment companies.
Okay.
So they are anyway available. I need not separately send a letter to them. So they are interested in buying shares in companies. So I can as well walk into their office and give them my projections and ask them to buy shares. You understand now?
Yes,
Whereas
sir.
here I'm addressing individuals who are not connected with me or whose business is not investment. So they're saying 200. They're excluding QIBs because anyway QIB I can approach even without private placement opportunity now. I can write a letter to the QIB and say, come and look at my company if you want to invest. They will invest.
Sir,
So,
and one more doubt, sir. And in case of deemed prospectus, sir, that second condition, sir, consideration point. Could you please explain it once again, sir?
Simple. I'm allotting shares to you today. If the offer is made within 6 months from today, also it is a deemed prospectus. Suppose today when I'm allotting shares to you, face value ka share is 10 rupees, premium 25, you have to pay me 35 rupees. Suppose you have not paid me that 35 rupees. You have paid me only 10 rupees. The allotment is made now. You have paid me only 10 rupees. Another 25 is still pending. The offer is made by the allottee more than 6 months, beyond 6 months. Even then, since the time of the offer, when he is making, the full amount has not been received by me, the document sent by him will be a deemed prospectus. Okay. Actually, there is a problem. If I have worked out the problem, you would have understood it, but time is not there. But if in the original lecture you listen now, I would have explained one problem. Similar example I would have given, where the offer is made 6 months later, but the amount is not fully received at the time of making of the offer. Okay. Yes, sir. Yes.
Okay.
Sumaya Mahek, I think you had a doubt. Hey, Anup, one more thing. The other day, you were making this comment about government company, that Bharat Biogas. Okay.
Yes,
see, there the time was not sufficient. Boss, think about it. First of all, Bharat NTECL, if it is a government company, how it will become government company? Only if central government and state government are holding more than 51%.
Yes, sir.
Got it? So in that case, that NTECL is a government company, no doubt about it. Okay. But Bharat Biogas, this government company is not holding more than 51%.
Yes.
Are you able to understand what I'm saying?
Yes.
So that the fact that NTECL is not holding more than 51% is very important.
Okay, sir. If it is holding, then
if it is holding, then there is no doubt about it.
Yes.
So that example was given in such a way that the government company is holding less than 50, central government is so together nobody is holding more than 50.
50. Yes.
That is the example.
Yes.
Yeah. Even if let us say that NTECL is a subsidiary of a government company, that will make NTECL a government company, but not Bharat Biogas.
Yes,
Not Bharat Biogas. I hope that day after you asked the question, there was no sufficient time to explain. Now I am explaining it to you correctly.
Okay. Thank you.
Yeah. See, withdrawal of application is simple, sir. A red herring prospectus is issued. Now, based on that red herring prospectus, I have made a bid. Now, subsequent to my bid, you have changed the price. I am not comfortable with the price. Then 5 days will be given for me to withdraw my application at any time. Even if in the normal current prospectus, many of these companies are coming out with red herring prospectus, which is basically having price band. Even there, once you select a price band, if the upper price limit is selected, those who applied in the lower price limit will have an opportunity to withdraw their application. That time should be given. Because you had a price band of 350 to 360 or 350 to 400. I applied 350. You allotted at 400. Then I should be allowed to withdraw at 350. That is always there. Okay. So, in fact, what they normally do, they fix 400. Then whoever applied at 400, they will allot. Less than 400, they won't allot itself because they know they can be withdrawn. That is why. Fantastic. Any other doubts, questions that you have? See, one more humble request. Please take the time to please go through the entire video. I hope the link has been sent to you. I know it's a little boring listening to me for 2.5 hours or 3 hours continuously, but still keep a notebook with you and sort of watch. Then if you have any doubts, write down in that notebook. For example, in the next class, I'm going to cover share capital and debentures. So please watch the video. That will be running into what, 2.5 into 3, 6 hours. So kindly watch it before day after tomorrow over a period of time. Maybe fast forward. Sometimes when I talk unnecessary nonsense, you just fast forward it. Whenever I talk about the topic, you listen again and then you go on going. And finally, if you have doubts, make a note in a notebook. Notebook mein likh kar dijiye. Then when you come for the class, you raise the doubt. And it will be my pleasure to answer it to you. Okay. Thank you. So shall we call it a day? Shall we say bye? Any other questions? Akash, you have a question? You have raised your hand, sir. Any question? Akash ji?
Yes, sir.
Okay.
Yes, sir. I
Yeah.
have a question, sir.
Yeah, please
sir,
ask me. Ask me.
First of all, sir, good evening, sir, and sorry, sir, for my lack of knowledge about
No,
the
it's okay.
Hindi.
Perfectly all right. Go on, go on.
Sir, still, I have a confusion regarding the board resolution and special resolution, sir.
Sir, board
Because, sir,
resolution will be passed
because-
only in board meeting. You
Sir,
understand? A director's
sir.
resolution.
Yes, sir. Yeah, I understand
So
it, but sir,
That's all. Where is the confusion here?
Sir,
Only
the-
directors meeting, board resolution will be passed. Only members ka meeting, ordinary and special will be passed. There
yeah,
will-
sir. Actually.
Now tell me where is the confusion?
Sir, the confusion is in examination, sir. Whenever the questions ask when actually the board resolution or the special resolution will be passed. So the timing, the time is my confusion. I mean,
What time?
yet which of time the board resolution will be passed and at which of the time the special
Sir, it is
resolution.
given in the section. If you know the section well,
Yes, sir.
very clearly you will know when board resolution, when special or ordinary. See, today we saw so many topics now. In all these topics, you saw only special and ordinary resolution.
Yes, sir. Yes, sir.
Where is the board resolution here?
No, sir,
Whereas
no,
in one
no.
topic for changing the registered office from one city, town or village, or in the same city, town or village, I
Yes, sir.
clearly put board resolution.
Yes, sir.
So where is the confusion here? If you know the subject correctly, you will not have any confusion.
Yes, sir.
You
And sir,
understand now?
yes, sir.
Between the two, there is no confusion. Your problem is you do not know when board resolution is required, when special resolution is required. Am I correct?
Yes, sir. Yes, sir. Exactly.
That can be rectified only by reading the section or reading the material and noting down and
Reg-
remembering. Yeah,
On the regular basis, sir. The regular
no other
basis.
way. Exactly. So
Yes, sir.
that is what we have
Sir,
also learned. Akash ji.
Sir, one more question, sir.
Yes, sir. Yes, sir.
Sir, you used the term the regular prospectus. Regular prospectus. Sir.
Regular
So,
prospectus.
yes, sir. So which prospectus is known as a regular
Simple.
prospectus?
Regular prospectus will be used only in the context of red herring prospectus.
Okay.
Basically,
Red
red
herring
herring
prospectus.
prospectus issued pehle when to the QIBs and HNIs and all that, which will not have
Okay.
price and quantity.
Quantity about the shares.
Once price is determined and quantity is determined, we'll issue a finally.
Shell prospectus.
That is called
Shell.
regular prospectus.
Okay. Okay, sir.
Good, sir.
Okay,
Thank
sir.
you.
Thank you, sir. Thank you, sir.
Yeah, Mr. Vamsidharan, sir.
Yes, sir.
You have
Good
2
evening,
minutes. You can ask. Yeah.
sir. Good evening, sir.
Good evening, sir. Good evening.
You explained about that red herring prospectus earlier.
Yes, sir. Yes, sir.
That so if in the red herring prospectus no price is mentioned or no number of shares are mentioned means will there be any chance for public subscription with red herring prospectus?
Oh, no, sir. Actually, I'll tell you what is happening. As propounded in your doubt, I'm able to understand where you're coming from. As originally announced, the red herring prospectus was supposed to be sent to QIBs and HNIs only. Are you able to understand? Thereafter, once the price was finalized, the bids were received, then a proper prospectus was prepared with the final price, single price and quantity and issued to the public and to the QIBs also. Then the QIBs got the chance to withdraw in case they don't want and then apply. So all the applications will be coming from on basis of the regular prospectus. Today, what happens now? Companies are not doing it in 2 phases. They are directly sending the same prospectus to both the QIB HNI as well as to the public. Therefore, the prospectus that you are getting is not a red herring prospectus. It has a price band, that's all. That is not a red herring prospectus. Whereas the red herring prospectus is one which is sent only to QIBs and HNIs. Where the rate won't be there, the quantity won't be there. Are you able to understand?
Yes, sir. Clear.
The prospectus that you are now seeing now with the price band, that is not red herring prospectus. That is ordinary prospectus. Except that it has a price band. That's all.
Okay, sir.
Okay. Yes. Thank you. So I think we'll have to call it a day. If you have further doubts on the same topic, no problem. Keep it in reserve. Next class we can ask. No problem. Okay. Thank you. Bye. Wish you all the best. See you again on 10th. Bye.
Thank you, sir.
Thank you, sir. Thank you, sir.
Thank you.